So, good morning, everyone. I know that what you want to do right before a long weekend is listen to lawyers. So, today we're going to try to mix it up a little bit. We're going to talk about student discipline. And just to give you an overview of our agenda this morning, we're going to talk a little bit about general discipline procedures. We're going to talk about the specific rules that govern students with disabilities. Then we're going to take a break. So you can refill your coffee, get some emotional support if you need it, because we're talking about discipline. And this is the time of the year where people are burned through their 10 days and they're wondering what they're going to do next. So you might need a break. And when we come back, we're going to have some of our volunteer thespians act out a manifestation determination review meeting. So that's our agenda today. I'm going to try to give you a framework for working through issues regarding student discipline. So my hope is that you walk away with an understanding and kind of a game plan for your next challenge, which, it's not if, but it's when. So a couple housekeeping rules. Number one, I will take questions throughout the session. However, I can't see the chat very well right now. So if there is a question, our lovely people from the SST are going to kind of flag me down and let me know that there's a question. So don't worry about interrupting. I just want to make sure that I answer the questions, in real time. I'm not going to necessarily stop to take a break, but certainly if you have questions during the break and you want to pop those in the chat, I will be able to take a look at that at the chat and then come back. So couple other housekeeping things. Number one, you're going to see a very lovely PowerPoint that was created by our team, but that PowerPoint is really just so you have something else to look at besides me. Okay. The comprehensive materials are the ones that are in outline form. They were sent to you, I believe, with registration. If you don't have access to them, please contact our folks at the SST, and because that will be what I'm working from. There's a lot of cases in your materials. I definitely will not have time to cover all of them, but they're there as a resource for you, and something that you can have, to take back to your teams to use for reference when you might need it. I'm not going to cover everything, but it is going to be going through. It's going to be the scope and sequence of how I get through this material, because there's a lot here. So we've got, let's see, my glasses on so I can see. It is a little bit after 9. We've got until 11:30. We probably will fill the entire time with our break, but I don't have time to cover every single case. So the first thing I want to start with is just an introduction, if you don't know me, if you haven't been to other ESELA programs. I'm Laura Anthony. I'm the chair of the Education Practice Group at Bricker-Graydon. I have been doing this work for about coming up on thinking almost 27 years. And the entire time I've been with Bricker-Graydon, the entire time that I've been with Bricker-Graydon, my focus has been on student issues. So I do a lot of work with civil rights, so individuals with disabilities, civil rights protections, other protected classes, any type of discrimination. I deal with discipline. I deal with all of the things that you guys deal with. So that's my bias. So if you are, if you're coming here as a parent advocate, any other role other than working with school districts or on behalf of school district, you might hear a little bit of a bias coming out there. I'm also the parent of a child with a disability, and I'm also the child of a parent with a disability. So although I have a bias in that I work every day supporting and working with school districts, I do feel like I have a unique understanding of issues that arise in this context. Okay, so that's number one. That's me. Number two, you're going to get to meet other folks who are on the Bricker-Graydon team. One of them, excuse me, Claire Parsons, is an experienced school lawyer who has joined our team this week. She's going to be participating in both our mock manifestation review, and she's also going to be, and Claire, I'm giving you permission, there to just kind of chime in and give some perspective. one of the things that Claire does and has done a lot more than I typically do is litigation in the special education context. So some of the things that we might talk about might spark an idea or a thought from Claire, and so she might pop in. So Claire, do you want to introduce yourself before we go farther?
Yeah, hi everybody. I am Claire Parsons, and I am actually in Kentucky right now. I joined Breaker Grade this week, so I'm brand new. So that explains the very white and boring wall behind me. I hope in future trainings to have more decorations. But I'm really happy to be here. I've been doing school law for about 15 years, primarily in Kentucky, but gradually doing more in Ohio. But I have done numerous due process hearings and proceedings in federal court over the years, including relating to discipline, and those can sometimes be some of the most intense cases and emotional cases. So I'm happy to be here and work with Laura to try to bring a little bit more calm and hopefully understanding to the process.
And so if you are entering your career as a special education leader, I want you to think about this framework because you might want to use it as you interact with people who might not get it, people who may be building administrators or others who take a different approach. In the world of special education, and truly in the world of most of the research about behavior management, there is a stark difference and a recognition of the difference between discipline and punishment. Okay. So let's talk about what that is. Punishment is a quick fix. Okay. It is something that is just going to stop the behavior immediately, maybe. That's the hope. It focuses on what happened, what action happened, not the cause of the action. It's just what did the person do? And based on the research and what people know about behavior management is that a punishment does not bring long-term changes in behavior. On the other hand, discipline is an approach to changing behavior through a lot of different things, through evaluating it, through planning for it, and through teaching. So the discipline approach provides appropriate consequences for misconduct and does result in long-term changes of behavior. It isn't focused on what did somebody do on this particular afternoon, this isolated behavior. Instead, it's really a learning process that provides somebody with necessary skills. So what do we think of suspensions and expulsions and emergency removal from school? Is that a punishment framework or is it a discipline framework? I will let you decide. But I can tell you that the approach that we're going to talk about quite a bit today in terms of managing behavior for students with disabilities is a discipline approach. Okay. When we think about functional behavioral assessments, we're evaluating. When we think about behavior intervention plans, we're planning. When we think about services and supports on IEPs, we're teaching. And so when and recognizing when there is something that is so dangerous that creates a safety risk in our school environments, we're removing, right? Because that is also an appropriate consequence to protect safety. So if you, in your work with building administrators or district administrators or board members or parents, I want you to be thinking about that difference between punishment and discipline and seeing what things you can do in your work to try to maintain the focus on a discipline approach. Not only is that what is legally required, but it is consistent with making long-term changes and helping students who may not have the skills to maintain appropriate behavior get those skills. Because if you think about it, just as you wouldn't tell a student who's moved into your district who can't read, you wouldn't say to them, you know what, you can't read, so go home, and once you can regain the ability to read, you can come back into our school district. There, the same can be said for a student who does not have the skills yet to maintain appropriate behavior. Go home until you can regain the ability. There just might be a lack of capacity in that regard. So there is, I'm going to be off my soapbox right now. All right. So in the materials, we start with a general introduction about discipline principles. And this is not specifically in the context of special ed. It is in the context of student discipline generally for regular ed kids and students with disabilities. But the general principles are articulated in a Supreme Court case. And in fact, and that's called Goss versus Lopez. That was a case out of Ohio, interestingly enough. And in that case, there was a lot of conversation about the discretion that is afforded to schools. Okay. And so the requirements are that schools have to give due process, right? Due process in the sense of the procedures. Now, Claire mentioned she's litigated a lot of due process cases. Those due process cases are different. So in special ed world, we call a due process complaint a complaint where a parent is saying, hey, school, I'm not happy with what just went on with regard to my student. And so I'm going to file this due process complaint. That is litigation related to special education programming and services. Okay. That's one way to think about due process. What I'm talking about is completely different. There is something called constitutional due process. And what happens in constitutional due process, very different concept. What it means is that before something is taken away from you, like your ability to attend school, before that is taken away from you, you have to do a couple of things. And in fact, there are three things. You have to give notice. That's number one. You have to give an opportunity to be heard. That's number two. And you have to afford people the right to appeal the decision. So those are the three elements of due process: notice, an opportunity to be heard, and an appeal. So how do we do that in the context of student discipline? Well, number one, the notice is you're having you're giving notice of what conduct is prohibited in my school, right? You've got a student code of conduct. It is likely posted in your building. Hopefully that's the legal requirement in Ohio. It is made available to people through the website, through the student handbooks. You give them notice. You're not allowed to do X, Y, and Z in school. Okay, that's number one. You also give notice that some sort of discipline is being contemplated. Okay, some sort of removal might be contemplated. I'm giving you notice of intended suspension. That's a requirement of our state statute 331366. You have to give a piece of paper that says, hey, I think this happened. You might be suspended for it. I'm going to meet with you. So that's your notice of intended suspension. And then what happens after that, so that's your notice requirements, then you give them an opportunity to be heard. So I think this happened. You might be suspended for it. The opportunity to be heard is, what do you have to say for yourself? And that occurs and it can occur in an informal meeting with the principal or the assistant principal. And the student says, it wasn't me. It's mistaken identity. That isn't marijuana. That's oregano in this baggie in my backpack, whatever it is. That's not my locker. That gun wasn't mine. They have an opportunity to respond. So notice, an opportunity to respond. And then after that happens, there's a decision made. Is the person going to be suspended or not? Or whatever is the consequence. And then you get a written, you are now suspended. And then the third thing comes in is they have a right to appeal. So those are the elements, and that's how our state statute works in terms of both suspensions and expulsions. Students get notice, an opportunity to respond, and the right to appeal. That right to appeal is to the Board of Education or the Board of Education's designee. Now, in some districts, I serve as the Board of Education's designated hearing officer. So I've had the opportunity to sit through many appeal hearings. And, one of the things that comes up frequently is in the discipline process, sometimes people say, "Hey, oh, by the way, I think this child is disabled and might be, need to go through the special ed procedures." I tell you that because it is helpful for those who are sitting in those roles as the appeal, maybe it's the board or the superintendent, the superintendent's designee, they need to understand the special ed process. Because when I'm sitting in that role, and maybe it's a child who hasn't been identified as a child with a disability, I need to redirect because the special ed process is special, right? It's a very different process. So, use these materials, take these materials, and determine whether or not in your district people other than those who are focused on special ed need to have this information. So, what I just described in terms of constitutional due process is the general rule. Okay, that's for children who are identified as students with disabilities, as well as students who are not identified as students with disabilities. And so I want to make sure that you know that this process, what I talked about, notice, an opportunity to be heard, and appeal rights, that has to go for all of the students. How specific does your notice have to be? Well, it has to you have to understand, individuals have to understand what conduct is prohibited. Okay. You can't have something that is super vague or overbroad. If you have a dress code in your school that says inappropriate dress will not be tolerated, that's not going to fly. That's not going to give people an understanding of, what attire, what appropriate attire is and what the expectation is. The rules should need to be school related. Now, you can use the authority of the school district to address off-campus misconduct. You can, use the discipline procedure for behavior that occurs off, not on the school bus, not in the school building. So those are things you can do, but there are certain things that have to happen first. Number one, your Board of Education needs to have a policy that extends its authority off campus. That is a requirement of the statute. And then what conduct can be addressed? Well, it is conduct that is related in some way to the district's educational program or activities, or conduct that is directed towards a school official or their property. So, if somebody is engaged in some, words are exchanged on the school bus, the students get off the school bus, or they're on the school bus and they're like, let's go fight over there at the park. Once we get off the bus, they go over there, there's a fight. Is that conduct connected to activities that occurred in school? Yes. So there may be that nexus between school and off-campus misconduct. Let's say what happens is kids get off the school bus, they walk down the street, they see the principal's car parked, I don't know, getting coffee at Starbucks, and they go and slash the tires of the principal's car. Is that conduct that is directed to a school official or their property? Yes. Okay. So that's the type of off-campus misconduct that can occur if it is authorized by your board's policy. All right. So that's all I'm going to talk about with respect to due process. Next, I want to do a little bit of a conversation about discrimination. And know that students with disabilities are protected from discrimination under Section 504. We're going to talk a little bit about Section 504 today, but as you probably know, we have an entire ESELA session dedicated to Section 504. So I'm not going to go into it in great detail, but know that Section 504 is not, and I've said this many times in programs, so forgive me if you've heard this before, but Section 504 is not the miscongeniality in the beauty pageant of special education. It is not second place. It is not the silver medal of special education. It is a separate and distinct statute that protects students from discrimination. Okay, so you should not be experiencing discrimination, meaning being treated differently based on a protected class of your disability status. Just like you shouldn't be treated differently based on your race, your gender, your age, your national origin, things like that. So a student could suffer disability discrimination under Section 504, in the context of discipline. Let's say they are treated more harshly than students who are not identified as children with disabilities. Let's say they're being disciplined for, ding, 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 behavior that is caused by their disability. So if you are being disciplined for behavior that results from your disability, that is a manifestation of your disability, that is potentially discrimination. And Section 504 has a procedure that requires a school to look at the relationship between a student's behavior and their disability. So if you are in a district in which there is a myth that students who are under Section 504 plans don't have to go through the manifestation review process, let me dispel that myth, because the manifestation review procedure actually comes from Section 504. In Section 504, and this could be a student who doesn't have a disability related to behavior. Maybe it's a student who has a peanut allergy. Maybe it's a student who has asthma or epilepsy. Any student who has been identified as eligible for protections under Section 504, it has to, before they experience a significant change in placement, which would be any removal for more than 10 days, they have to have an evaluation that looks at the relationship between the behavior and their disability. So know that that manifestation review process exists there. What also could be discrimination on the basis of disability status? That kind of discrimination could come up in the form of bullying, where a student with a disability is either being bullied for something related to their disability, or they are being the bully because of something related to their disability. So know that if there is somebody saying something in a bullying investigation that sounds like, looks like, seems like I'm being treated differently, or they're picking on me because of my disability, because I'm going to the nurse's office to get medication, because because the class is not allowed to have a Halloween celebration because I have a peanut allergy. Like, all of that's bullying and harassment of a student with a disability can rise to the level of disability discrimination and can result in a denial of faith. It can also constitute a civil rights violation that could lead to big money damages against a school district. Whenever there is anything that is civil rights kind of implications, that's where I say that that's big dollar signs. So, if another takeaway from this program is you should have some conversation with those individuals, if it's not you, who are investigating bullying claims in your district. So our state statute is 3313-666. I love that. 666 is for bullying. And so that, I'm pretty sure that's it. I'm second guessing myself. Anyway, we've got a bullying statute, and it requires the principal to conduct an investigation and issue findings, and there's written notices. If that principal is just kind of going through and doing the bullying investigation and does not recognize that when he hears something like that sounds like or seems like disability implications, the bullying investigation that the principal is doing needs to stop or just take a pause, and that principal needs to contact the district's civil rights coordinator, because your district likely has policies that say that govern investigation and complaints of disability discrimination. So somebody has to recognize when a bullying investigation morphs into a disability discrimination claim, because it is likely that two different people have to do those different procedures, and there are two different kind of timelines and steps. So homework assignment for you would be to check your policies. Some of them, if they're Neola, would be 2260.01, and ACAA, I think, in the context of OSBA, and that would be disability discrimination. And then looking at 5517.01 in Neola, and I can't think of the one in OSBA, but they're different. So bullying and disability discrimination complaints, different, okay? And people need to recognize that, because if you don't, then there's the potential that the district could be on the hook for not following their um, discrimination complaint procedures, and that in and of itself could be a violation. All right, I am going to pause and see if there's any comments in the chat that I need to see.
We don't have
No.
anything in the chat right now.
Awesome.
Hey,
Thank you.
Laura, can I chime in just a second?
Yes, Claire, do please.
So on 504 and IDEA, many times IDEA kind of takes precedent in terms of thought process because the procedures are much more intense under IDEA versus 504, and even the legislation, the statute, it's just much more minimal in comparison to IDEA. But just as a refresher of where we are on the law, IDEA, you could end up in a due process hearing. 504, you could actually end up in court directly, and there could be suits for money damages and greater liability, even risk of liability potentially for individuals in some circumstances. So it's something to be mindful, and most likely this crowd understands that, but it may be something where you can help other administrators understand the potential risks and consequences. So it's just something to be aware of with that distinction. And with the Supreme Court's ruling on exhaustion and making that 504 option more readily available, I do anticipate, I think we've already seen more cases coming to court much quicker than in previous years.
Absolutely. Thanks for that.
And then, yeah,
I
and Laura,
see.
now that we've paused, do you see the questions?
Yeah, I see. So
Okay.
how does this apply to preschool, pre-K, 504, and IDEA? So how it applies is, IDEA governs students who are in preschool. So, all of the concepts apply. Section 504 applies if, you're running an education program and you're receiving federal funds. So it's going to apply. All of that. You made a comment about a student having a peanut allergy and being suspended for 10 days. I can't see all of that. For some
They're
reason.
asking if they have a peanut allergy, but they don't have an IEP or 504, is there a manifestation meeting needed?
Well, the question that becomes, should they, and we're going to do a mock manifestation determination meeting about a kid who isn't currently identified. The question there, and we're going to get into this as part of our framework, the question is, should they have been? Did we not meet our requirements for child find under section 504? Okay. A kid with a peanut allergy, and I have a kid who has a nut allergy, can be a student who meets the criteria as a child with a disability under section 504, or they may not, because the answer depends. And we talked about this a lot at the section 504 session. How you can be eligible is, do you have a significant impairment of a major life activity? Some people with allergies, their impairment is my mouth itches when I eat a peanut, and that's it. Some people with a peanut allergy, when I eat a peanut, my throat is going to close and I might not be able to breathe. Is that a significant impairment of your major life activity of breathing? Yes. So, the takeaway here is, when you have something that is a health condition, you should be thinking about meeting your child find obligations under section 504. So the answer to that question depends on whether or not the district met its obligation under child find. All right, getting back to the materials, we're now going to go, outside of the world of what applies to everybody, which was our due process procedures, are the pieces of paper, the notices, all of those things, the hearings, the appeals that apply to all students. And now we're going to talk about those special rules that apply to students with disabilities. Okay. Now, many times I have been asked, hey, just give me a flow chart. Like, I need it. And, with all due respect to building administrators, but I've been asked a lot of times by special ed folks to say, can I have something where it's just easy, like very just step one is this, step two is that, here's a flow chart, because my principals don't get it. Well, I did a couple years ago. Our team put together a flow chart, and it was like 5 pages long. It had arrows from the back to the front. There's just so many different detours in that flow chart that it's just not not flow chartable. And I think at one point, SST, tell me if I'm wrong. At one point, ODE put up a flow chart for special ed discipline process. I don't think it's up there anymore. In fact, and I think number one, my comment is it was not complete, but I don't think it's up there anymore. It's just not a flow chartable thing. It's not something that really lends itself to that framework. I will give you a different framework, and hopefully you can work through that in a little bit easier of a fashion. That framework requires you to always, always, always ask 4 questions. And I'm going to go through those 4 questions. And once you go through the decision trees with those 4 questions, you should have a game plan. Okay. But as some background, why do we have different rules for, well, I would say some enhanced rules for students with disabilities? Well, it's because of that thing that I talked to you about at the very beginning, because the IDEA has the perspective of a discipline approach, not a punishment approach. And the discipline approach recognizes that all students, including students with disabilities, deserve, a safe and secure learning environment, and that teachers and school administrators need to have tools and strategies to help prevent misconduct and discipline and discipline problems, and to address students who have discipline challenges. And so this discipline approach takes like a balanced perspective with respect to managing student behavior that reflects these 2 needs. Like, we need to have a safe environment, and we also need to teach behavior sometimes. So, and then finally, the approach recognizes that by law, students with disabilities have a right to a free and appropriate public education. Now, there is some language in 1998, so that a couple years ago. Well, when I started at Bricker, which was 1997, shortly thereafter, there was an OSEP letter that came out from the U.S. Department of Education Special Ed Program. That's what OSEP is, and they kind of had a great quote, which I always like to read because I really think it tells the tale of what was in the mindset when the 97 regs came out. And they said, cutting off, and I'm reading this, cutting off children with disabilities from educational services is not an effective punishment. So here we go, got that word in there. Instead, providing these students an effective alternative program increases their chances of becoming productive law-abiding members of their communities. We believe that continued services are essential to ensure that disabled students who are subjected to disciplinary exclusions from school do not fall farther behind and are able to gain behavior once they return to school. So that's the perspective, that's the approach. Okay, continued services. So I'm going to talk a lot about day 11 services. I want you to think about that in your mind. We're always going to be thinking about services on day 11 because that is the requirement. So when balancing the need for safe learning environments and continued services to students, the IDEA in the language that talks about FAPE, what is a free and appropriate public education? That definition of FAPE, both in the Ohio operating standards and in the federal law, says that a free and appropriate public education has to be available to all children with disabilities residing in the state between the ages of 3 and 21. So there you go for that preschool question, including, and this is the language, including children with disabilities who have been suspended or expelled. So that tells you that the expectation is students with disabilities who have been suspended or expelled continue to be entitled to services when starting on day 11. Okay, so there is no set of circumstances, and sometimes I get this question, there is no set of circumstances under which you will be done providing services to a child with a disability who's been removed from school for some sort of behavioral issue. Okay, you will always be at least on day 11, responsible for those type of services. Okay, so this framework also requires a proactive approach to managing student behavior. How do we do that? We do that through positive behavioral interventions and supports. Remember the word positive there. We do that through providing, evaluating behavior through functional behavioral assessments. And we do that by including in student IEPs services designed to manage behavior, right? Remember, you have that box that you have to check in Ohio. Those Ohio IEPs have that box in the special factors page that says, does the student have behavior that interferes with their learning or the learning of others? If so, you got to check the box and you got to address it on the IEP. Okay. So,
Can I jump in, Laura?
yes, absolutely, Claire. Thank you.
I don't like interrupting. This is hard.
No, you have permission to interrupt because I can't see you.
So yeah, everything Laura is saying is correct, but I wanted to just add, she's talking about law and process a lot. And just a practice tip is to remember that there are humans in the decision-making roles for all of these processes. So when you're talking about discipline, the focus and the mindset is generally it is on the student who is accused of a disciplinary violation. My experience is any decision makers in that process are concerned about the individual student and their welfare, and they are reluctant to expel and sometimes even approve suspensions because they know that kids being out of school is not what we want. But there is a broader focus on the school community and overall safety and welfare of all students that balances that. When you go to a due process hearing under IDEA, you're going to have much more extensive proof about that child's background and history and all the things that they are dealing with and all the challenges they have. And then there is also going to just be more focus and expectation on what have we been doing to help this student. So the mindset going into these different processes is different, and it just will kind of just really emphasize an expectation that there is a proactive approach to help students in disciplinary who have discipline behavioral needs under IDEA.
And part of that proactive approach is making sure people know what the standards are, because so often you get into a situation where people are like, I didn't know, or I don't know what to do. And to build on Claire's point, it's not only humans making the decisions in the moment on the IEP team in the classroom, it's also human beings making decisions on the bench. And there's a lot of times where students with disabilities make very sympathetic plaintiffs. And if we're not following our process, if we're not seeking help or expertise when we don't know how to manage a student's behavior, that does come back to bite districts. I had a situation where we were dealing with a disability discrimination federal litigation, and the district just didn't follow its bullying procedure. And we may not have had an issue on, was there an impact and did the student suffer some sort of harm? But just solely on did we follow our own procedure, the court was really hammering the district on that because they wanted to see that the proactive supports are in place and that the process is followed. So both from a substantive and a procedural, know that those can be exposures for you, and that when the human beings on the bench see the sympathetic student, that doesn't always go well. Anything else to add on that?
I would also say, I know in behavior cases, there also tends to be badly behaving parents. But in many cases, even those badly behaving parents have some sympathetic stories to them. There can be poverty or other educational limitations. There just can be a whole lot of stress in the family. And so even if they're not doing everything they're supposed to do, that's not always an argument you can rely on. It's not even an argument you can always effectively make because of optics or other aspects of the case. So even when the parent is not ideal, in many cases they aren't, we still are expected. I mean, the government is always expected to follow its own rules and to have the documents lined up and in order. So when you don't, that is just an exposure factor.
Absolutely. See, I told you might need some emotional support after, during the break, because I'm putting all this heavy stuff on you guys. All right. So how are we proactive, right? We've got your IEP team has to consider the use of positive interventions and supports, right, to address behavior. not only behavior that's big, not only externalized behavior, right? It's not only the kid who's throwing the chairs that you have to deal with. Maybe it's the kid who is, curled up in a ball under the chair or putting their head down. Maybe it's this internalizing behavior that is interfering with that student's learning as well. So think about when you're checking that box, you've got to do that and know that it is regardless of disability category. So you might have a student with a speech language impediment and impairment, sorry, and they're experiencing some behavior. It's not just the students who are identified as other health impaired or emotionally disturbed. And then are you being proactive in monitoring the, the amount of time that the student might be subjected to disciplinary removals? There's no bright line test when a student that those disciplinary removals might trigger a child find obligation, but know that if there's been a referral to your IAT group, right, and that referral is related to discipline, you might be in the realm of having a student who may be entitled to discipline protections, and that we will be talking about that when we get to question 2 in our 4-part questions. Okay, just want to see if there's anything else I need to cover with proactive approach. Let's just talk a little bit about functional behavioral assessments and behavior plans. So number 1, lots of stuff in your materials about this. So, understand we're still going to go back to proactive approach, Maya. For your functional behavioral assessments, understand that the purpose of the functional behavioral assessment is understanding, right? So it is something that you are identifying the problem behavior. You are making sure that there is some sort of observation of the student in various settings. You are collecting data, whether it's behavior incidents, antecedents, consequences, and then you're looking at that to try to understand it. You're trying to develop a hypothesis about what caused the behavior. And then you might need to test that hypothesis and then take additional data and then present your conclusions to the team. When do you have to do that? Well, you have to do it when the discipline is a change of placement. Okay, so that's a requirement. When should you be doing a functional behavior assessment? Anytime. It's always appropriate anytime there's behavior that interferes with that student's learning or the learning of others. Who has to do it? There's nothing specified. There isn't a specific person on the team who's required to do it. Parents might say it's required to be done by a certified board certified behavior analyst. That's not legally required. Maybe your school site can do it. Maybe you have a behavior specialist in your district who has a level of expertise, and training on this. You do need consent. I mean, there's some. I'm gonna modify that. There is some legal authority out there that suggests that you need consent. And under a conservative approach, we usually say that consent is required. There has been a case where that has been called into question, but I have been in many complaints, and ODE usually says consent is required. Let's see. What if the parents disagree with the functional behavioral assessment that the district obtained? In 2009, the U.S. Department of Education Special Office of Special Ed Programs issued a Q&A and said, yes, the parents, if they disagree with the FBA, they can obtain an independent evaluation at public expense, subject to the independent evaluation procedures. After that, if you go through your functional behavioral assessment, you are to have a behavior intervention plan. And the goal of that plan is not to articulate all of the different things you're going to do as punishment to the student. The goal for that plan is to teach appropriate behavior. So I have just something that I think about when I'm looking at behavior intervention plans. And these, for those who've heard me speak before, I always try to have mnemonic devices and things to remember. So here's something to remember. There are 4 P's in your BIP. 4 P's. This is how you evaluate your behavior intervention plan. The first P is what I've been talking about, being proactive. You need to address the behavior before it becomes a significant problem and subject to discipline. So the behavior intervention plan should not be a list of consequences. You need to have strategies to prevent behavior. So that's your P. You're being proactive. The second P is that it is positive. Remember the difference between punishment and discipline. So behavior intervention should not be, another P, punitive. They should emphasize positive approaches to shaping behavior. Okay. The next P is that you've got to be persistent. You've got to be persistent and implement the behavior strategies on a consistent basis. Okay. And you need to be persistent when you find that the plan is not working. You've got to update the plan. It's not a static document. And then the final P that you need to think about when you're evaluating, are you on the right track, is that it's in the name, plan. There has to be a written plan that is developed with thought and individually tailored to a student. So if you have a one size fits all approach, like this is our classroom management strategy where we're moving the the clothesline and the pin from red to green, that is not a behavior intervention plan. That is not individualized to the student. Now that might work for a student, but it might not. So if the child in question needs something, individualized, the plan has to be specific to the child's needs. So that's just a little bit more in getting into deeper about the behavior intervention plans and the functional behavior assessments. There are lots of cases in your materials where we talk about those things. But in the interest of time, I'm not going to get into those cases.
Neither one tidbit on this, Laura. On the plan, the team should be clear on what exactly is the behavior intervention plan. I did get a litigation matter once where the behavior supports were identified in the IEP. And I think they were honestly fairly on the right track. But part of the argument from the parents was that there was no behavior intervention plan ever written for the student. And I tried to argue that what was contained in the IEP constituted that, but we didn't really win on that issue. Ultimately, we did okay on the relief, but we did kind of get dinged on that. So be clear on what your behavior intervention plan is, because you may not be able to defend if it's just some document that isn't clearly identified and designated, and the team is not like totally on board with all the steps.
Yeah, great comment. All right. The next slide is about restraint and seclusion. I do have information in your materials about restraint and seclusion, but I don't have time to cover those. That really deserves its own conversation, but just know that, we do have standards in Ohio. There are reporting standards, there are documentation standards. There is a requirement to be proactive and look at behavior and plan those thoughtfully. But what I want to move into is our conversation about our 4 questions. Okay, so this is our framework for analyzing any special ed discipline situation. Okay, you always have to look at these 4 questions, and I'm going to go through them quickly, and then we're going to go into them individually. So just as an overview, question number 1 is really easy. I think we'll move to that slide. Question number 1 is the child currently identified as a child with a disability? Okay, that's easy. Yes or no? Okay. Do they have an IEP? Are they currently identified as a child with a disability? Easy. Next question. If not, they're not currently identified as a child with a disability, is the student considered a suspected disabled child? Okay. A child who is suspected of having a disability. Okay. This is where it gets tricky. Okay. And I'm just going to tell you the last 2 questions, but I'm going to stay with this slide because we're going to spend some time here. Because these first 2 questions are basically saying, do we even have to worry about these special ed rules? Okay. Once we decide we do, because the child is currently identified or they should have been, and we have to treat them as if they were identified, then the final 2 questions are, what are we thinking about? Okay, this is number 3. What is the nature of the intended disciplinary consequence? Is it a long-term removal? Is it a short-term removal? Is it a change of placement? Is it sitting out from recess? Is it being suspended from the bus? Like, what is being contemplated here? Because that's really important. It tells you what happens next. What is being contemplated tells you how to get there. Okay. And then the final question Question number 4 is there a safety risk here? Remember that balancing approach where we want to have safe environments? Well, there's a couple of, you know, conduct violations that on their face creates different procedures because they are unsafe. Okay, so now those are your 4 questions. Is the child currently identified as a child with a disability? If not, are they considered to be a child with a disability? What is the nature of the intended consequence? And do we have a safety issue? Okay. I told you we're going to spend some time on question number 2. Is the child somebody who we're going to consider as a suspected student with a disability? Okay. Here's where it gets tricky. How do you become a suspected student with a disability? Okay, and I believe this might be on our next slide. You do that. Oh, okay, keep going. All right, go back. We're going to go back. Back. Go back because I guess I don't have a slide on this. All right. Let's go to considered. Okay, so this is in your written materials. So this would be something that you want to, this would be the place I would reference and tab. So in your written materials, how do you get to be a child who's considered to be a suspected disabled student? The child gets that protection once the district has knowledge that the child may be a student with a disability. Okay, so there's this whole concept of the district has knowledge. Now, I have used this analogy before. I've used this analogy year after year after year, and I'm going to do it again because it helps me. So maybe it'll help you. Who remembers the movie? And now Timothy Chalamet is in it, is in the revival, or the origin story of Willy Wonka and the Chocolate Factory, right? And I'm talking about the Gene Wilder version because I'm not going to even consider the Johnny Depp version. But in the Gene Wilder version, if you have gray hair like me and you grew up with that movie, loved that movie, I'm going to talk about a scene in that movie that I think encapsulates all of this. And I have a little prop here. Okay, here's the scene. So at one point, all the kids who have the golden ticket, here's my post-it note, it's just my golden ticket. All the kids who have their golden ticket, they show up and they want to go into, the chocolate world, right? But Gene Wilder is standing there as Willy Wonka before he opens the door, and he's like, okay, you are about to enter this place. Here are the rules, right? Like, don't touch anything, don't eat anything, right? But you're about to go into this, great place because you have this golden ticket. I'm about to open this door. People remember this scene? I'm gonna think that those of you with gray hair are virtually nodding. Anyway, you have to, how does this at all pertain to special ed, Laura? Well, it's one of my favorite movies. So that's why I'm going to talk about it, but it also pertains to special ed because there's a lot of kids who are out there who have the golden ticket of special ed discipline protections in their back pocket. And you have to know when you are opening the door to that world or closing the door. Okay. How does that door get open? And the door is open when the district has some knowledge that the student is suspected of being a disabled child. That door can be opened and the golden ticket can be obtained 3 ways. So there are 3 ways to open that door, and there are 3 ways to close that door. The first way, the parent of the child expresses concern in writing to a supervisor or administrator or to the teacher of the child that the child is in need of special education and related services. How could that happen? And you won't know the thing about it. Maybe the parent writes an email to the teacher and says, hey, my older child might, is on an IEP. I think my child, this student might also need some services. That's it. Guess what? Door opened, golden ticket. Number 2, the parent requested an evaluation of the child. When could that happen and you not know about it? Maybe it's at a parent-teacher conference because you know what? It doesn't say anything about being in writing. So that, could be somebody saying something at a conference and nobody does anything about it. And guess what? Student is suspected disabled. They have the golden ticket and they are able to take advantage of the discipline rules. And the third way, and this is something you have control over, is that the teacher of the child or other district personnel expressed specific concern about the student's pattern of behavior to somebody who can do something about it, like the director of special ed, maybe that's you, to a principal. Okay, so somebody is expressing concern. It's not the lunch lady expressing concern to the bus driver. It is the teacher or somebody else, other district personnel expressing concern to somebody who can actually, process that as a referral. Okay, so those are the three ways that the door is opened. And once that door is opened, regardless of when it happened, did the door open in third grade and now we're dealing with a discipline issue in eighth grade? The door is still opened. Okay, what does that mean? The door is open, meaning you have to think about day 11 services and manifestation reviews and all of the other things, even though the child doesn't have an IEP. Okay, I said that there were three ways that the door gets opened. There's also three ways you shut the door. Okay, we shut the front door. You know what I mean? Okay, so we shut the front door by taking those three things: parent expresses concern that of the need of special ed in writing, request an evaluation, or teachers express concern about a pattern of behavior, and you do something about it. You go through and you request consent. So the first way to shut the door is if the parent refuses to allow the evaluation. They refuse consent. That's one way that the door gets shut. Second way that the door gets shut is if you go through, you ask for consent, you do an evaluation, you determine that the child might be eligible, and you offer an IEP and the parent refuses. So that's the second way. Parent refuses consent, or the parent refuses services that you're offering. Okay. And the third way that you shut the door is if the school goes through the evaluation process. You issue prior written notice, you plan the evaluation, conduct the evaluation, you meet, and you determine as a team that the student doesn't meet the eligibility criteria as a child with a disability. So that's number 3. And then you issue notice, prior written notice, does not qualify. Those are the 3 ways that you shut the door. And, golden ticket no longer. What doesn't shut the door? So in Ohio, we know that there is not evaluation on demand. So you can, after the parent requests an evaluation, you can meet as a team and decide you do not suspect a disability. And you can issue prior written notice that says we are declining to evaluate. However, we get another Post-it note. The golden ticket still exists. So even if and let's say that happened in the 3rd grade, we did not do an evaluation. That did not shut the door. All right, I do see that I have some questions. Claire, while I look at the questions, is there anything you want to add?
Just yet another raising of consciousness to the evil that is email sometimes. I have done an expedited due process hearing under IDEA on the issue of basis of knowledge. And it was many days of misery going through and fly specking different emails between staff and some of the parents, trying to differentiate just expressions of frustration versus actual requests for services and things like that. And we fortunately won in that case, but just be aware as a training tip for your probably more lower level staff, your teachers and other folks, what we're putting in emails and what we should not, and just the importance of sometimes walking to someone's office and having a conversation or picking up the phone versus email.
Great. So the question here is, so if the door is open, but the district has not determined there is a suspected disability within 30 days of parent request, the student has protection. Yes, door is open. Okay. The other thing I would add to Claire's point about email is that sometimes we don't know what's in the emails until the lawyers request all of the documents and we find that. So just, this information, and I know that there's so many here who are seasoned special ed folks. This information needs to go to your teachers. They need to know when to report up to you that there has been this referral. Otherwise, it's just going to sit in the emails. There are so many times when I've been called by the district and I will say, okay, they'll say, well, can we do this? The child's not disabled. And I was like, oh, but wait a minute. We've got to look for the golden ticket. We've got to ask those questions. And they're like, what do you mean we got to ask those? Yeah. because then we need to know what happens next. That's why this is question number 2, because unless we know who is entitled to the protections, we don't know what happens next. All right, I think I'm going through those scenarios. So if the door was never opened, okay, you didn't, and you didn't have any knowledge that the child was a child with a suspected disability, what do? Well, you go through your regular education procedures. And if during the hearing, like the discipline hearing, the expulsion hearing, somebody says, oh yeah, guess what? By the way, my child's been diagnosed with, all of these different alphabet soup diagnoses, then you're going to have to say, well, the district had no knowledge. There was no door opening. And so we are required to conduct an expedited evaluation. What does that mean? It is less than 60 days. And during that time, the student can be removed, okay? But you have to do an expedited evaluation, okay? All right, what happens? Let's see. Oh, and the student is going to be removed. So that's what the students stay put. All right, so that's questions number 1 and 2. Do I have another question? Let's look. I do. All right. The door to these protections is open if there's ever any kind of conversation about potential disability. No. Okay. The door is open if the parent requests an evaluation, and that is in a conversation. So request for an evaluation can be a conversation. The door is open if the parent expresses concern in writing. So that could be an email that the child might need special ed. And then the third way is if there is an expression of concern from school personnel about the student's pattern of behavior, the door is open. It's not if there's a conversation that the student might have a speech and language impairment or the student has a reading deficit, not about a potential disability on the part of the school personnel. So that's where the limitation is. So the parent has to express concern in writing that the child might need special education, not in behavior, anything. Or they have to request an evaluation, not regarding behavior, anything. But if the school expresses concern about the student's pattern of behavior, those are the 3 ways that the door gets open. Hopefully that's clear, but that's how your materials read.
Can I add on one little thing? I think that might be best practice for forwarding those issues up to your lower level staff, because we still have child find 2 outside of discipline. So that might be best practice, but Laura's limitation in this context for the basis of knowledge is I agree with that.
All right, so now we've determined who is entitled to these protections, what are we going to do? What is next? So now the next question is, what is the nature of the disciplinary consequence? What are we thinking about? Is it an in-school suspension? Is it a bus suspension? Is it, sitting at the study carrel during your recess? Is it Wednesday school, Saturday school, whatever it is? So let's talk about in-school suspensions. So if a student is not being removed from their educational program, that may not count as a day of removal, but be cautious here, because a lot of schools have these, alternatives to discipline when they actually are a removal. So you have to look at, is your in-school removal, your in-school suspension, your shifting to an alternative school, is that removing the student from their educational program? Meaning, are they getting their IEP services? Are they getting to progress in the general ed curriculum? And are they participating with non-disabled students to the same extent as they would have had they remained in school? So kind of an LRE-ish conversation. So if you answer those questions of, yeah, they're getting their regular ed, they're getting their special ed services, and they are not being segregated on the basis of disability, if that's how you're going to answer that question, then that in-school suspension or in-school removal is not going to count against you as a day. But I will tell you that most times that's not happening. Maybe it is in your school, and great if it is there.
Yeah, I have an add-on on this. So if you're looking at the materials on page 15 and all of those elements for in-school suspension, the second question is not just, is this happening, or do I believe this is happening? The question is, can you prove each of those elements are happening? Because it is much more difficult than you would think. So When it comes to a student has the opportunity to continue their IEP services, what individual at that school is going to come and testify that they came in and gave the student their minutes? What documents are you going to be able to produce to verify that those services occurred? So service logs or whatever, monitoring data or whatever. So you have to think very practically about proving this, because hearing officers will be exceedingly skeptical of you. I've dealt with this in litigation too. So there's just a difference between what you think is happening and what you can prove.
I love that. That's great. Yes, and sometimes I say, if it's not in writing, it didn't happen, right? So you have to be able to prove it. Okay, so that's in-school suspension. What about if you're removing a student from the bus? Well, the standard here is that the question that you need to ask is transportation a related service on the IEP? Because all of this is focused on, are we removing students from services that they are legally entitled to? Okay, so if transportation is a related service on the IEP and you remove the student from transportation, even if mom takes them to school, that is going to count against you. Okay, but if transportation is not a related service on the IEP, then that bus suspension is not going to count as a day of removal. So, think about it in another way. If we removed the student from their speech therapy, that's a related service. So if you've designated transportation as a related service, you're going to have to be thinking about counting up the days when students are removed from the bus. All right.
Laura, can I ask a clarifying question there
Yes.
as well? So if a student is removed from the bus, but it's not a related service, but parents cannot transport them to school, would that count as a removal?
No,
No, it would not. Okay.
it would not.
All right.
Now,
Thank you.
does it make does it make people nervous? Yes, but no, it does not. So that's a caution to IEP teams that, for purposes of determining when transportation is a necessary related service, you do need to be thinking about, what is the student's disability and why do they require specialized transportation? Do they need a wheelchair lift bus? Do they need an aid on the bus? Do they need a bus equipped with, certain, safety harnesses? Do they need somebody who is trained to administer, diastat or, an EpiPen or things like that? So special transportation is related to a student's special education need, not the parents don't have a second vehicle or don't have a job that is flexible to be able to provide transportation. It is related to the student's disability. That's the intention there. What about
There was a question that popped up in the chat too, just before we move on. It said, so if any kid has ever had a behavior plan, would the district still consider that they had suspected disability?
So if the question is assuming that the behavior plan was developed because school personnel expressed concern about the student's pattern of behavior, yes. Okay, because that's one of the ways that we open the door. Now, remember, just because the door got open doesn't mean you can't close the door, right? And you can close the door by wondering, asking for consent, doing the process of evaluating the child to determine, do they meet the criteria as a child with a disability? Because let's say, let's take it out of context. So maybe you have a student who's on a behavior plan because the student just experienced the death of a parent and having to be relocated, living in a foster placement, or living with Uncle Joe, whatever. And that kind of disruption to their home life has created some reaction from the student. And maybe in the short term, that student needed a behavior plan. But maybe the student doesn't meet the criteria as a student with a disability because there's no adverse effect on their education, or maybe there's no, maybe they don't qualify at ED because it hasn't been over a long period of time and to a marked degree. So you could have a student who might have some behavioral challenges in the short term and not meet the criteria as a child with a disability, but you have to go through the evaluation process in order to shut the door. Okay. All right. Other disciplinary consequences could, what if the plan is part of MTSS? I mean, there is no reference to that. So if the plan is related to the student's pattern of behavior and you're going down that road, yes, the door would be open unless you shut it. Other disciplinary consequences like that don't result in any removal of supports are not going to trigger these IDEA steps. Okay. So remember, we're talking about what is the nature of the disciplinary consequence, and we just discussed non-removal from school, bus, study carrel, Saturday school, detention, those things. Okay. Next, we're going to move into removals. So if you are looking at a short-term removal, less than 10 days, the IDEA authorizes school officials to remove students. You're allowed to remove students. This is where this balancing of safety, safe and secure environments, and allowing teachers to be able to focus on teaching, but only for a short period of time. So less than 10 days, less than 10 cumulative days, less than 10 days in a row, the IDEA allows the district to remove a student without continuing services. So that's why I call them day 11 services, because you have days 1 through 10 where no school day is required. No school services, no services are required. Okay. How do you calculate a day? Well, the IDEA regulations define a school day as including a partial day. This is from the 2006 regulations. Any partial day, sorry, there's something in my eye, that a student is removed from their educational program. So, and who's keeping track, just like Claire said, who's keeping track of the school day? And, how do you define a day? Well, I define a day as any time the school has unilaterally removed the student. And that could be a suspension. That could be an emergency removal. That could be an expulsion. That could be hey, come pick up your child. We need a mental health day. They need a mental health day. I need a mental health day from them. They're having a meltdown. Come get your child. That doesn't include your child's having a rough day. Can you give us any suggestions? And the parent says, they didn't sleep great last night. It's best that I come pick them up because they're just not at their best today. Okay. And how are you documenting that? There are many, many, many times I get into situations where the district says we've only suspended the student for 7 days, and we get into the hearing and the parent has, 12 more days where it's been, hey, come pick up your child. Somebody needs to be tracking that because you need to know how to count to 10 and what data you're using to count to 10. So, who is monitoring the amount of removal and for what purpose? Do you have any way to prove it? The reason that this is so important is once you get to the fork in the road where the removals constitute a change in placement, you have to do certain things. Okay. Before we get to that fork in the road, let's talk about those day 11 services, which was on the last slide that Maya had up. So day 11 services are services that a student is going to receive that are designed to enable the student to make progress in the general ed curriculum and advance towards their IEP goals. Okay. Many districts get hung up on this. And Claire, I don't know if you saw this, in your work in Kentucky, but many districts in Ohio have this philosophy or myth that every day of removal needs to be addressed with 1 hour of day of home instruction. And so some districts believe that there's this formula that you apply for day 11 services. That's so easy. It's an hour a day. That's a myth. The day 11 services are those that are required by the student by virtue of their disability. And so if you are not having a change of placement, which is what we're going to get to next, who decides those services? It's the teacher in consultation with the school. Okay, the teacher decides, or the school decides in consultation with the teacher what services are provided. But if it is a change of placement, which we're going to talk about, it is an IEP team decision as to what services are provided. Claire, did that myth exist in Kentucky when you practiced there?
No, we have some restrictions on home instruction by statute in Kentucky, so we haven't had that. But I've heard other ideas like that in other contexts.
Okay. All right. So now we are at this point, because remember, we're under the question of what are we considering? What discipline consequence are we considering? Is it a short term? Is it a long term? Okay. Once we are considering a removal that constitutes a change in placement, we've got a lot of process that we have to go through. Okay. We've got to have the IEP team determine what day 11 services are. And it is that time, that fork in the road, when it's a change of placement, a disciplinary change of placement, that is the point that triggers the manifestation review. Everything we've just talked about, days 1 through 10, short-term removal, removal from the bus, you don't have to do a manifestation review. And so if, you might want to just pause. I'm going to say that again. You don't have to do it. Don't do it if you don't have to do it. Why convene a team if it is not legally required? Once you get to a change in placement, then you are required to conduct a manifestation review. Okay. That is the time and the fork in the road that you have to, to do it. So what constitutes a change in placement? How do you figure out what that is? Okay. So remember, we have this idea about 10, which sometimes gets confusing, but a disciplinary removal will constitute a change of placement, and this is in your materials. Disciplinary removal will constitute a change of placement under 2 circumstances. You go for more than 10 in a row, so more than 10 consecutive days, not 10, more than 10. Okay. Or the child has been subjected to a series of removals that constitute a pattern. Okay. A series of removals that are more than 10 and they constitute a pattern because the child's behavior is substantially similar in all of these situations. And because of additional factors, like the length of the removal, the total amount of time the child's been removed, and the proximity of the removals to one another. Okay, so I'll give you another movie image to think about. Maybe those of you who have gray hair remember the mockumentary called Spinal Tap, which is a mockumentary about a rock band. And in one of the scenes, the old rocker was talking about volume of their music. And he was always talking about it. We like to turn it up to 11, even though the volume dial only goes up to 10, we like to turn it up to 11. So I want you to be thinking about that if you've seen that movie. When you've turned it up to 11 is when we're at a change of placement, potentially. Okay. It's 11 consecutive days. So in Ohio, that's going to be any expulsion. Because in Ohio, the definition of a suspension is 10 days or less, and expulsion is more than 10 days. So any expulsion is going to turn it up to 11. And then if you've got a series of removals, we've got 4 days here, got 4 days there, and you've got another 4 days. Now we've got 12 cumulative days. Now I'm going to be looking at, is there a pattern? Because I've turned it up to 11. And let's say the first 4 days was for being insubordinate. Okay. And the second 4 days is forging your mom's signature on an excusal form. And then the last 4 days is vaping. Okay. Is that behavior that's substantially similar? Probably not. But if it's 4 days of insubordination, 4 days you're cussing out the teacher, and 4 days that there's a fight, maybe that all seems like substantially similar, or maybe it's fight, fight, fight. Okay. Then once we've turned it up to 11 and it's a pattern, now we're in a change of placement. Okay. So what happens now that you know that there's a change in placement? What comes next? Well, you've got now let's go back. When is the decision made to change placement? It's not when there's a notice of possible expulsion, because maybe the kid's not going to be expelled. It's when the superintendent says you are expelled, or the principal says you are suspended, and that suspension kicks it up over 11, and it's a pattern. Okay. Once that decision is made, okay, so that date where it says you are expelled, now the team has to convene and the manifestation determination must take place within 10 school days of that decision. So many districts, I know, do the manifestation review before it ever gets to the superintendent's desk. You can do that. It's just not legally required. Okay. It is the legal requirement is that once the decision is made to change placement of a child with a disability, and that decision is a disciplinary change of placement, the school has 10 days to convene the team and conduct the manifestation review. The U.S. Department of Education's Office for Special Ed Programs has clarified the manifestation determination is not required when a removal is being considered. So intended suspension before you even meet with the superintendent, it's triggered on the date that the decision is made to implement that. Okay, who does the manifestation review? You are going to see that acted out. It is relevant members of the IEP team. Maybe it includes the bus driver if something happened on the bus and the student's being expelled from school because of that. What do we have to consider? It's all relevant information contained in the student's file and information that from the teachers and any information provided by the student's parents. So they could on that day come in and hand you an evaluation and you'll see that acted out. Okay. So what does the team have to do? You'll see this again acted out when we get into our mock. You're looking at what is the relationship? Is there a direct and substantial relationship between the disability and the misconduct? Or was the conduct the direct result of the district's failure to implement the IEP? Okay. So that's what you're looking through. And there's many cases in your materials about different decisions in which teams were challenged on their manifestation review and what was found to be legally compliant, not. Now, when you're looking at this relationship, it is a causation relationship. So it's not some attenuated relationship like, oh, my child has a reading disability, so they have low self-esteem, so they come to school with low self-esteem, that's why they got into a fight. No. Okay. That's not it. That's not a direct and substantial relationship. What happens if the conduct is determined to be a manifestation of the child's disability? If it is, the student is, you're conducting a functional behavioral assessment, you're implementing a behavior plan. If the behavior plan is already in place, the team has to review or modify the existing plan, and you are returning the child back to school. Okay. This is something that a lot of building administrators don't understand. If the child's behavior is a manifestation of the disability, the student goes back to school in their pre-disciplinary placement unless the parent agrees, because in Ohio, we have, you have to get agreement to change placement. The parent could say, you know what, student's not doing well, we just changed medication. Yes, this was a manifestation of the disability, but I'd like him to, be in an alternative school or something like that. Parent could agree to that, but if they don't agree, they go back to school. If the conduct is determined not to be a manifestation of the disability, then the student may be removed, suspended, or expelled, just like any other student, but day 11 services apply. Then student has to receive services as determined by the IEP team that are necessary for the student's needs. All right, that's our manifestation review. The final question number 4 is there some concern about safety? Did the misconduct occur some special circumstance? Again, everything's special in special ed involving safety. And that would entitle you, with the reason that we ask this question now is that now we have to figure out, is there some sort of exception? Because if we've done the manifestation review and we find that the behavior is a manifestation of the child's disability, we might be able to remove the student, even though it's a manifestation of their disability, if it's a special circumstance involving safety. Now, these circumstances are very limited. It is drugs, weapons, or serious bodily injury. If those things happen, and we'll define that in a minute, you can remove the student for up to 45 school days, okay, to an interim alternative educational setting. So this applies, this exception will be there if the student carries or possesses a weapon at school or on school premises or brings it to a school function. There's a definition in your materials of what constitutes a weapon. Okay, and there's some case references about what constitutes a weapon. Most things like a paper clip or a pencil or, scissors with dull blades, not going to be considered a weapon, but you can that stuff is in your materials. Um, that's number one. That's one special circumstance. Second one is they knowingly possess or use illegal drugs, or they sell or solicit the sale of a controlled substance while at school, on school premises, or at a school function. Again, definitions in your materials about what constitutes an illegal drug. And then finally, which we'll spend a little bit more time on, if they have inflicted serious bodily injury on another person while at school, on school premises, or at a school function. Okay. What constitutes serious bodily injury? I hope that you never see something like this. But serious bodily injury is much more than a cut, a bruise, an abrasion, my feelings were hurt. I think somebody might hurt me, a threat of bodily injury. It is very serious. It is something that happens. Somebody goes to the hospital, somebody gets medical treatment, somebody can't return to work for a long period of time. They need surgery, their jaw was dislocated, their ear was ripped off. I mean, this is serious stuff. Let me read to you the definition. The term serious bodily injury means bodily injury which involves substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of the body member, organ, or mental faculty. Okay. Contrast that with the definition of not so serious. It's not what it says, but it just says regular bodily injury is a cut, abrasion, bruise, burn, or disfigurement. So not obvious disfigurement, physical pain, illness, impairment of the function of the body member, organ, or mental faculty, or any other injury to the body, no matter how temporary. Okay, so in your materials, there are some cases interpreting what constitutes serious bodily injury. If you get into a situation and you want to use this exception, know that it's a pretty high standard, and I would have you talk to your legal counsel about the circumstance so that you know that if you can, if you can go down that road. So as an example, let's just say the student gets on the bus and pulls a knife on the bus driver. Okay. And the student is recognized as a student who has paranoid schizophrenia. They are a student who is hearing voices. They believe that the bus driver is there to abduct them, to take them to another planet. Okay. Was the student's behavior a manifestation of the child's disability? Yes. Okay. Is this a special circumstance because they brought a weapon on the bus? Possibly. We have to look at the definition of a weapon. The definition of a weapon includes a knife with a blade of more than 2.5 inches in length. So again, a lot of it it depends. But if that is a big knife, right, and they come on the bus, you can remove that student to an interim alternative educational setting for up to 45 school days, because that was a special circumstance involving safety. That's how it plays out. All right. Let's go to our last slide, I think here is about appeals, I believe. Yes, discipline appeals. So remember that there is an appeal process under the regular discipline rules that we talked about. And there are appeals that parents can do in the special ed world. So as Claire mentioned about due process hearings, parents can challenge through due process if they disagree with your determination about the manifestation review. And if they disagree about an action taken concerning discipline, they have a right to an expedited due process hearing to challenge those things. What does expedited mean in that context? Typically, what happens is it's very fast. Cases are litigated and the decisions are issued within 20 school days. And so it's not something that, if something happens like that, please call your legal counsel, because they need to get working on that very quickly. A hearing officer is appointed and testimony is taken, and it goes quite quickly. So there are various ways that parents can appeal, both under the special ed rules and the regular ed rules. Pause to see, do I have any additional questions? Oh, yes, there's a big one here. Okay. Oh boy, lots of stuff. Okay. So Head Start has unilaterally shortened a guy's school day without an IEP team. If they've been doing that all year, he is already over 10 days, right? On number A, I would can't give legal advice during these things. And so make sure that you're talking to your legal counsel because there's always a lot of things that are related to shortened school day. If it is a unilateral decision, and it is not with parent input, that would be something that I would think would create some exposure. And or disability discrimination. I've seen cases in which the U.S. Department of Education has found a violation when there is a shortened day because of the need to get on a special ed, bus with a wheelchair bus, and that students miss part of their day just because of transportation. So I'd be careful about that. What if the parent is requesting the change of placement? Does there need to be a manifestation? Great question. No, because if the parent is requesting a change of placement and the team agrees to that, we're not in discipline. That is not a unilateral disciplinary removal. That is an IEP team coming to a decision about the student's needs. Okay. That is parent agreement and IEP team decision, not discipline and, disciplinary consequences. So I rarely get that scenario, but yes. If a parent calls and requests for the parent to come in and get the student, if the school calls and requests the parent to come in and get the student and the parent refuses to pick up the student, does that still count as a removal? I guess the question becomes, what was happening with the student? Did they sit in the office the whole time? Did you call the police and have the student removed? Like, what was happening in that? Oh, Claire already answered it. Great. See that. Awesome. All right, we are at 10:37. If no further questions, what we're going to do is we are going to shift to our volunteer thespians, and we are going to come back, let's say 10:37, let's come back at 10:50. Okay, and we are going to do our mock manifestation review. And if there's any questions in the meantime, let us know, but I'll put in that we are going to break until 10:50. See you then. Don't freak out if Kristen and I and whoever else shorten up our comments. Okay. So I'm going to try to make the best use of time. For the rest of the folks in the audience, I'm going to move over to our mock manifestation slide. I think is our first slide. Maybe. Maybe there's, oh no, keep going. Oh, we're going to skip those. They're in your materials. It's all the things I've already talked about. It's just a reminder. All right, going back. All right, so we are going to do this mock manifestation. We've got people who are playing different roles as actors in our dramatization. Now, our dramatization takes place at Pleasantville, which is a rural school district. We're going to be meeting in May, and we're talking about a disciplinary event involving a brother and a sister, Jack and Jill Simpson, who've both been recommended for expulsion. Jack has been identified as a student with an emotional disturbance. He has an IEP. He has a couple of different diagnoses: bipolar, anxiety, oppositional defiant disorder, and his IEP focuses on strategies. He's got a behavior plan to help manage his anxiety in school. Jill is his sister. She's a freshman. She has ADHD. She takes meds at home before that ADHD, but she's not been identified under IDEA. She does have a Section 504 plan. She's got extended time, preferential seating with that plan. She did have some suspensions in middle school, but she's been recently exhibiting some inappropriate types of behaviors at home and at school. And so here's what happened. Jill was caught trying to sell her ADHD medication to another student at school. During the sale, she sent a text message to her brother to tell him that the person who was buying the medication was giving her a hard time about the asking price. And when he got the text, he became agitated and he tried to leave his own class. When the teacher stepped in front of Jack and told him he couldn't leave, he punched her in the face. That broke her glasses and cut her face. So Jack was suspended for assault, recommended for an expulsion for 80 days, and Jill was suspended for possession and sale of the drugs. She was also recommended for an 80-day expulsion. So we've got The person who's playing the role of the intervention specialist, me, is I'm going to be the intervention specialist, and I'm going to be a very new intervention specialist. I wasn't there the day that this happened, and I'm very new at my job. We've also got Mr. Rooney. Claire is going to be playing the role of Mr. Rooney, our high school principal. You may recognize Mr. Rooney from Ferris Bueller's Day Off. He's been Jack's math teacher for the past 2 years, but he's now become the acting principal when our high school principal was placed on administrative leave. We also have Miss Smiley, our regular ed teacher, who I believe that Maya. Maya's playing the role of Miss Smiley. She's moved to the high school from the middle school, and she's currently the science teacher, but she also had Jill in class during middle school. We've got Ms. Moneypenny, the Director of Pupil Services for Pleasantville. I believe that's being played by Kristen, correct?
Yes, Laura.
Okay. And then we've got, and Miss Moneypenny, she's been just like in the Bond movies, she's been around for a really long time. She's a veteran. She knows everything. Miss Bask is our school psychologist. Miss Bask just happened to be in the hallway administering a test to a student when she overheard Jill's drug deal. So we've got Miss Bask, and then we've got the parent who is who will be playing the role of Eve Simpson, Jack and Jill's mother. Who is that? Oh, that's Kristen. Kristen Piercy is going to be the mother. Eve Simpson is very nervous and concerned about her children. She's especially worried about Jill, who she suspects may be kind of heading down the same road as her brother, Jack. She's communicated these concerns to the district, and she's had Jill privately evaluated. So we're going to start with scene 1.
Good afternoon, everybody. We need to talk about Jack's assault on one of our teachers on Friday before spring break, which was 3 weeks ago.
Right. Yeah, we're here today to do a manifestation determination. So to help us along, I've made copies of the manifestation determination worksheet so that we can all follow along as we go through the meeting.
I'm confused. What is a manifestation determination? I mean, I thought we already had this meeting when I met with the principal and the superintendent before Jack was expelled.
This is a process that we go through to examine the relationship between Jack's misconduct and his disability. The team is charged with considering whether Jack's behavior was actually caused by or had a direct relationship to his disability, or if it's the result of the district's failure to implement the IEP. Does that make sense?
Yeah, but before we get started, there's something I'd like to ask. I know that we're here today to talk about Jack, but I'm also very concerned about my daughter, Jill. Basically, I just don't think her 504 plan is sufficient. I mean, since the incident that involved Jack also involved Jill, I mean, I'm hoping that we can talk about both of them today. I mean, would that work?
Well, as long as we can be done in an hour, I'm okay with that. I have interviews scheduled for substitute teachers.
Oh, okay. I didn't realize that we had a time limitation. There wasn't one listed on the invitation.
All right, so as I'm going to do, we're going to take a break every once in a while to see if we can spot any legal issues. So number one, we've got, I told you that the manifestation determination meeting has to be performed within 10 school days of the decision. Here, we probably have a timing issue because we talked about it. This happened a couple of weeks ago. Next, we're going to talk about it. Do we have the right people here? Do we have the relevant members of the IEP team here? So remember, need to have the parent. We've got to have, we've got the district representative, Miss Moneypenny. We've got an intervention specialist. We don't have one of Jack's regular ed teachers. We've got Mr. Rooney can serve in this role, but since Mr. Rooney was Jack's regular education teacher at the beginning of the year, that could work. So then mom says, hey, I want to also talk about Jill. And that we've got Jill who's already protected under section 504. So we do have a requirement to do a manifestation review for Jill. So Jill's already been identified as a child with a disability under section 504. She might also have the right under IDEA because she might have that golden ticket. We'll see what happens. And then finally, mom said, hey, I didn't know that there was going to be a time limit on the meeting. Rooney is clear that this is only going to happen for an hour, but the parent might have a very different perspective on that. So is it a problem to place a time constraint on the meeting at the outset? If you didn't put the beginning and ending time on your IEP invitation, consider doing that as a matter of course, just so that there is a shared understanding of what happens, and you just don't start off a meeting by, having a challenge about time. So let's see how Miss Moneypenny handles all of these issues.
I think we can make this work. Let's first start with Jack and do the manifestation determination on his assault charge, and then we can turn to Jill and do the manifestation determination for her drug charge.
Are you kidding me? Jill gets a manifestation determination too? She's just got a 504 plan, not even an IEP, and she's dealing drugs in my school.
Ms. Rooney, she's identified as a student with a disability under Section 504, and that means that before we can do a significant change of placement, and we would consider a removal for 80 days a significant change of placement, the law requires us to do a quote-unquote evaluation, which is why we need to do the manifestation review. Basically, we can't put Jill out for conduct related to her disability. So we'll have to look at doing a manifestation review, not just for Jack, who's on an IEP, but also Jill, who's on a 504 plan. With that in mind, Mrs. Simpson, are you all right with us moving forward with both reviews today?
And Kristen says, yes, certainly.
I see that she nodded yes. Okay, great. I know we had this meeting scheduled for only 1 hour, but because I want to make sure we have enough time to do both, can we please make sure that we go ahead and make arrangements to stay beyond the original hour if we need to?
Yes, I can.
I could stay.
Me too. I can't. I got interviews scheduled this afternoon.
Okay, well, I think for Jack's manifestation review, we have all of the relevant members of the IEP team. We have Miss Ice, who's the special ed teacher, Miss Smiley, regular ed. I'm the district rep. However, we do seem to be missing Ms. Bask, our school psychologist. She'd be able to help us understand the things related to the students' disabilities. Do you think we might want to call her in? She'd be relevant for this discussion.
She's actually conducting interviews of substitute teachers right now.
Yeah, well, I think we might need to relieve her of that duty and ask her to join the meeting, especially for Jill's portion. Wasn't she the primary witness to Jill's drug offense?
Oh, for crying out loud. Tell you what, I'll go cancel the next round of interviews so both of us can be here for these meetings.
All right, time for a break. So let's talk about the role of the district representative here. The district rep really is a key player in this process and has to have kind of the level of calm and knowledge and authority that we have here with Ms. Moneypenny. So it's important to remember that this school district does speak through the district representative. And, we would love it if there was never any kind of Ms. Rooney's out there, like nobody's rolling their eyes or having big sighs or making any kind of inflammatory remarks. But, oftentimes that's not what happens. So you might have a Rooney type administrator in your district who makes these type of reports and these type of remarks. But if you're the district rep, it's important that you're remaining cool and focused and ensuring that the legal requirements are met and that you diffuse any insensitive or inflammatory comments. So we will see how Ms. Moneypenny does that. What about the Section 504 manifestation reviews? Who does that? What team does that? Know that the Office for Civil Rights says that the people who do that are the same group of individuals who make the eligibility determination.
When I've got into some of these, I've had to turn it all the way, like take it off of the sensor.
Hi, I think we have somebody who's not on mute. So we're going to go back and rejoin the meeting.
Ms. Simpson, are you all right with having these people present for both manifestation reviews?
Yeah, that's fine.
Okay, now with all this legal mumbo jumbo out of the way, we can get started with determining whether or not these delinquents are guilty. This school has a zero tolerance policy for drugs and violence, and students who violate it are expelled.
Ms. Rooney, the purpose of a manifestation review is not to decide guilt or innocence. While you're right that the district does have a zero tolerance policy for serious offenses such as these, our purpose here today is to decide whether or not Jack or Jill's conduct is a manifestation of their respective disabilities.
whatever. Let's just get started. Miss Ice, can you tell us what happened when Jack slugged you?
Well, he didn't actually hit me. I was out sick that day. You know that intervention specialist who models eyeglasses on the side? She's the one that he hit. He knocked her in the face, he shattered her eyeglasses and cut her pretty severely.
I saw the substitute right after the incident, and she was bleeding, and she had a gash on her cheek from the eyeglasses.
Now, Miss Moneypenny, I understand we have to go through this touchy-feely manifestation process, but when a kid physically assaults and causes physical damage to someone, can't we just put the punk out of school?
Why don't we go ahead and hear the whole story before we jump to conclusions? Miss Ice, were you done reporting on the incident?
Oh, I've got a lot more. That sub was really mad. She left me a 2-page single-spaced incident report about it. I brought some extra copies. Does anybody want to see it?
All right, then now we're getting somewhere. What does the write-up say?
Well, it says that Jack was sitting near the front of the classroom and she thinks she heard, some sound. And so she turns to look to see where that sound was coming from. And she catches Jack staring down at his pants, which she thought was really weird. She wrote in the statement that Jack is like squirming and rocking in his seat. So she thinks that maybe he's sick or needs to use the restroom. So she goes up to him and says, "Hey, do you need to use the restroom?" And he says, "No." And he says he's yelling at her to like stop being so nosy. Then Jack gets up, heads towards the classroom door and says he needs to go down the hall. So it looks like she stepped in front of him and asked to tell her what was wrong and that he started pacing back and forth near the door, breathing really heavily. She asked him to sit down. She tried to calm him down, and he started yelling that he needs to leave now and get out there. And the teacher, I think, is worried that he was like hallucinating, like what was out there. So at that point, he lunged at her out of nowhere and punched her right in the nose. That's when her eyeglasses shattered and he bolted out of the classroom. And in the documents, she says, I quote, the quote is, "He's hysterical and totally out of control." And she then had some other details about how she dealt with her injury, but that's pretty much it.
Well, I say that teacher deserved to be punched.
Geez, lady, no wonder your kids are in trouble. Why would you say she deserved to be punched?
Because she didn't follow Jack's plan at all. I mean, the plan says that when he gets agitated in the classroom, when he starts to squirm or pace or breathe deeply, he's supposed to be allowed to leave the classroom to go see his counselor to work on calming strategies. I mean, in fact, when we had the meeting where we developed that plan, we even came up with a code phrase for him to use when he needed to go down to see his counselor. So his classmates didn't know where he was going. I mean, the code phrase was, "I need to go down the hall." That's exactly what he said. But instead of letting him go, the teacher blocked the doorway and just agitated him more.
Miss Ice, did you happen to bring a copy of Jack's IEP and behavior plan today?
Oh yeah, I have a couple copies. They're both right here.
And another question, Miss Ice, did you happen to leave a copy of Jack's IEP and behavior plan in your sub file that day?
Well, I didn't because I would never put anything in a substitute teacher file that is like confidential, like an IEP. I just keep my lesson plans in there.
Okay, well, obviously we do need to discuss what goes in a substitute teaching file.
All right. So, and scene. So let's talk about what has to be reviewed at the manifestation meeting. So as I mentioned earlier, the team's review has to you have to look at all relevant information in the child's file, so including the IEP, and any relevant information provided by the parents. So the team not only has to review the notes from the substitute teacher, but also the IEP, which includes the behavior plan. Next issue is an allegation about failing to implement the behavior plan. So in this case, the team has to consider whether the assault was caused by or had a direct and substantial relationship to the disability. That's one, or whether the assault was the direct result of the district's failure to implement the IEP. So here it appears that the behavior plan wasn't implemented by the substitute teacher. She didn't even have it in the file. And the plan that allowed Jack to remove himself from the classroom when he was agitated wasn't followed. So the question then is, you've got two situations because maybe Jack's anxiety, which is one of his disabling conditions under ED, that may have manifested in the physical aggression against the substitute teacher. And then finally, confidentiality. So in some of our other sessions on procedural safeguards, we talked about the fact, I can't remember if it's either the next one or one we've done already, but if you attend our session on procedural safeguards, you'll know that certainly IEP documents are confidential records that are protected from release for disclosure, to other people, but not to the people who need to implement those IEPs. So a substitute teacher would be somebody who had a legitimate educational interest in that document. And so disclosure to the substitute teacher of the IEP document would not be a violation of confidentiality. And then lastly, a practical issue is one about handling parents' frustration. So it's understandable that Ms. Simpson is, frustrated about the fact that the behavior plan wasn't implemented. And, she's saying, well, that teacher deserved to be punished. And Rooney's response is not uncommon. Well, let's see how Ms. Moneypenny handles this.
I understand that this is a very difficult and frustrating conversation for everyone at the table, but I want to assure you that, Ms. Simpson, that we're here to determine what's appropriate for Jack.
Look, I'm sorry. I shouldn't have said that earlier. Of course, she didn't deserve to be hit. I mean, Jack is such a strong boy, and I know he can be scary when he gets in one of his moods. I mean, I'm just angry because I think this whole thing could have been avoided. I mean, I do think that what happened was because of his disability. I mean, everything in that teacher's report and everything Jack told me about it, I mean, convinces me that he was agitated and he just needed to step out. But that teacher blocked the doorway and then his ODD just kicked in.
I agree. The confrontation by the substitute teacher would just exacerbate the behavior of an agitated student with a diagnosis of ODD.
Is there any disagreement on this among the team members? All right, I'm seeing everyone shaking their head no. Okay, well, we're also charged with looking at whether there was a failure to implement Jack's IEP.
Okay, maybe it was a problem.
I think I have to agree too that behavior plan just wasn't followed.
I would agree.
Well, then it looks like we do have consensus here. I do want to mention at this point, for the benefit of our teachers, since we do have so many substitutes in this district, that FERPA does permit us to disclose personally identifiable information to people who have a legitimate educational interest in knowing that information. And certainly subs who are going to be implementing IEPs and behavior plans in our teachers' absence have a legitimate interest in knowing what's in those IEPs and behavior plans.
All right, well, if you're sure, I'll add them to my subfolder.
I'm very sure.
Me too. But really, what difference does any of this make? Why does it matter if it's because of his disability or because we failed to implement a behavior plan? He caused serious bodily injury to that eyeglass model.
I've heard that if a student causes seriously bodily harm or injury, the district can place them in a disciplinary placement for up to 45 days, regardless of whether it's related to the disability or not.
Okay, wait a minute. So you're telling me that even if the misconduct was a direct result of his disability, and because your employee failed to implement his behavior plan, you can still discipline him for it?
Sure we can. That's why it's called zero tolerance.
This sounds like zero common sense to me.
All right, well, we're going to take another break. So at this point, Ms. Rooney is right that there are these special circumstances. We talked about those, and that you can remove a student without regard to whether the behavior is determined to be a manifestation of the child's disability. And that includes if they cause serious bodily injury. So let's see how these special circumstances play out in the team's discussion.
Well, Ms. Bask is right here in that there is a special circumstances exception that applies if the issue involves school safety. It applies when there's weapons violation, drugs, or as Ms. Rooney said earlier, serious bodily injury. But in this case, I don't think we really, I think we really need to take a look at the definition of serious bodily injury. That's defined as bodily injury which involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or a protracted loss or impairment of a function of a bodily member, organ, or mental faculty. It's very serious, and I'm not sure that punching a substitute in the nose, even when it draws blood, and even though the sub happens to be an eyeglass model, would constitute serious bodily injury in this case.
It doesn't sound like it.
No, it doesn't.
Good grief. Are we still in America? The kid smashes a teacher in the face and we can't discipline him?
No, Ms. Rooney, in this case, we can't. In fact, Ms. Simpson, the law requires that we return Jack back to school.
Oh, thank goodness.
In addition to that, the law requires that when the team concludes that the misconduct was a manifestation of his disability, that we either conduct a functional behavioral assessment or create a behavior plan. Or when the behavior plan is already in place, as it is here, the team has to take a look at whether the behavior plan and see whether it needs to be amended or modified in any way to address the conduct.
I don't think the behavior plan needs to be modified. I mean, he's doing really well in my class. I just think the problem was the sub didn't have it.
I agree to a point. In this case, do we know whether Jack was asking to self-remove because he was really agitated or only because he got a text message from Jill?
Well, I mean, I think the text message did agitate him. I mean, it would upset anybody to know that their little sister was in trouble.
Or that she was causing trouble?
Well, I agree with Mrs. Simpson that the written report of the substitute indicates that he was truly agitated. She indicated in the report that he was pacing and breathing rapidly, and those are classic signs of anxiety.
Okay, well, it sounds like the behavior plan is fine. We just need to make sure, excuse me, that it's in the sub files. And so, Ms. Simpson, Jack may return to class immediately.
Oh, that's terrific. Thank you so much.
All right, well, let's do some more issue spotting. So what just happened here? Once we determined that there is a manifestation and that there's no need to amend or change the FBA, and he already has a behavior plan. So the only thing that's left for the team to do is return Jack to his regular placement. If the district really wanted to pursue a change of placement now over Ms. Simpson's objections, they could do that, but they wouldn't be able to do it unilaterally. They would have to go through a due process proceeding, this litigation, or get a court order, but it doesn't appear that they're going to do that here. So let's see how the team considers what's next for Jill.
Okay, let's move on to Jill. Since Jill's on a 504 plan and she's not receiving any actual special education, is it all right if we excuse Miss Ice, our special ed teacher, from the meeting at this point?
Sure. I don't know that she has anything to add about Jill. Thank you.
Now, as I indicated earlier, Section 504 requires that before imposing discipline, a team of knowledgeable persons convene a meeting and do an evaluation. Part of that evaluation is to determine whether or not the conduct is related to that student's disability. And if it is, then OCR tells us that we have to do a complete evaluation of that student to determine if their placement's appropriate. If it's not related to her disability, then we may impose discipline on her just as we would with any other general education student.
So I don't know if this is the right time to bring this up, but in addition to the manifestation determination, I would like to talk about Jill's general behavior in general, which I'm growing more and more worried about. I just think she's been moody and withdrawn lately, and as you know, she's had a number of disciplinary reports over the last few years for things like not following the rules, being disrespectful, sleeping in class. I mean, in fact, Miss Smiley and I have discussed and exchanged some emails about whether Jill might need special ed like Jack. I mean, I'm just concerned that she's emotionally troubled like her brother and may need more intense supports in school.
You're right, Mrs. Simpson. We have talked quite a bit about your concerns, as well as mine, that Jill might need some extra supports as she advances in school and the demands on her increase. I've known Jill for several years now, and recently I've noticed an increasing number of disciplinary infractions. but there doesn't seem to be any pattern. They all seem to be for different things.
Look, everyone can use more support in school, but it's no mystery that Jill is a teenage girl. Random trouble is expected with teenagers. Adolescence is not a disability. If it were, the entire high school student body would have IEPs.
Well, I understand that to some extent, but as you know, I have two other children, and Jill, like Jack, is different. In fact, I recently decided to have Jill evaluated by Jack's psychiatrist, Dr. Doolittle. And I have a copy of her report. It shows new diagnosis for Jill, depression and a mood disorder. It also has several new educational recommendations for Jill.
Okay, that's nice, and we can look at it another time, but I'm getting annoyed that we keep getting off topic here, which is whether or not we can discipline this girl for selling her medication to another student. I won't have a drug pusher in my school.
May I see a copy of the report? Thank you.
All right, we're going to take a break to do some more issue spotting. So the one question is something we talked about earlier. Is Jill entitled to the disciplinary protections of the IDEA? So you heard the mom say and exchanged with, there was exchanges by email with Miss Smiley that she has expressed concern that the student might need special ed. And so here we go. Jill also not only has the 504 manifestation protections, but she also has it under IDEA because she's got that golden ticket because her parent has expressed concern in writing to a teacher. What about this private evaluation? That's our next issue. Does the team have to consider it? Well, remember that what the team considers in a manifestation review is not only the relevant information in the student's file, but what the parent is bringing to the table. So the team should take the time during the meeting to consider the information from this private evaluation. Let's go back to the meeting and see what happens next.
All right. Now that we've taken that break to review Dr. Doolittle's report, and given what you and Ms. Smiley have shared with the team, I think we as a district probably need to consider Jill as suspected disabled under the IDEA. In fact, that's why we've asked Ms. Ice to return to the meeting. It appears that you've expressed concern in writing to her Ms. Simpson, to her regular education teacher, that she may need special education supports.
Again, why does it matter whether she's suspected disabled under the IDEA? We're already doing the manifestation determination under Section 504.
So the difference is in the forms and the procedures that we have to use. Also, there's a difference if this team determines that Jill's misconduct is not a manifestation of her disability and imposes discipline, which constitutes a change of placement, meaning more than 10 days, because Jill would then be entitled to services starting on day 11.
Now, it seems to me that there's no way that Jill can be disciplined for having sold her ADHD medication. That was clearly an impulsive act, and it was tied to the ADHD.
Ms. Simpson, do you know if Jill took her medication that day?
Oh yes, no, I give it to her every day. It's 15 milligrams of Adderall in the morning, and then she takes it again later at school.
I reviewed the medication log and she took her medication that day.
So I think it's important to remember that not only does Jill have a diagnosis of ADHD, but according to Dr. Doolittle, she now also has a diagnosis of mood disorder and depression.
That's a really good reminder for the team. Let's take a look at the conduct. Ms. Smiley, do you have any reason to believe that Jill's 504 plan wasn't being followed?
Oh, actually, she had just left my classroom for extended time on her science test when the incident occurred.
I don't have any reason to believe that it wasn't being followed either.
Okay, that's good to know. Ms. Bask, I understand you were an eyewitness to the event.
Yes, I was.
Could you share with the team what happened?
Yes, I can. I was in the hallway when Jill came around the corner and met a boy in the hallway. They were about 25 feet from where I was. The acoustics in the hallway are very good, so I could hear everything they were saying. The boy asked Jill if she had taken care of what they talked about yesterday. And Jill replied that she'd taken care of it because she needs money for a new phone. and that she's done this so many times that she almost has enough money for one. At that point, Jill's back was to me, so I could see she was getting something out of her pocket, but I couldn't see what it was. And then the boy said, "I thought you'd take Ritalin." And Jill said, "No, Adderall." Then the boy said, "5." And Jill said, 10. And then the boy said, "Well, that's too much and not what you told me yesterday. I'm going to rat you out to Rooney." The boy then left and went into the restroom. At that point, Jill got very nervous, and I could see that she was getting something out of her pocket, and she started typing rapidly on her phone. I went into the nearest classroom and asked the teacher to call Mr. Rooney. Then, when I came back to the hallway, I saw Jill and the boy talking again. The boy handed her $10, and Jill took a plastic bag and handed it to him. Mr. Rooney came around the corner, and they both tried to run from him, but he was able to catch up with them.
At first, they both told me that they were just standing in the hallway talking about phones. When I asked them why they had run, they just shrugged. So I asked the boy to open his hand, and he had a plastic bag with a 15 milligram Adderall pill in it. He pointed at Jill and said, "She gave it to me." So I took them both down to the office and started the disciplinary paperwork. He gave me a statement that pretty much tracks with what Miss Bask says, and Jill refused to talk to me.
So there was nothing that I witnessed that would suggest that Jill was selling her Adderall because she was depressed or had a mood disorder.
No, but I mean, she was acting impulsively. She obviously couldn't control herself or think before she acted. I mean, why else would she sell medication with an adult 25 feet away?
Well, I think she was foolish, but I don't think she was impulsive. It was clear from what I overheard that the students had planned to meet in the hallway ahead of time. And they'd even talked about the price of how much the drugs would cost. So this was clearly a planned behavior, not
I,
impulsive.
I could not agree more.
I agree too. It's not the action of a kid acting impulsively.
Mm.
I think that's correct. It appears that Jill's conduct is not related to her disability. I think we have consensus among the team on this.
No, we don't. I mean, I don't agree. I mean, don't you think that with all these new diagnoses that Joel might be like her brother? I mean, it seems to me that the district should evaluate her before this decision is finalized.
Good grief. What kind of evaluation is going to tell us it's okay to sell drugs in school? Besides that, it takes months to do one of those evaluations, and we're almost at the end of the school year. Our school psychologist doesn't work during the summer.
All right, well, we're going to take a break and let everybody calm down. So let's talk about Ms. Simpson's request for an evaluation. So if we're treating Jill as if she was a child with a disability, an evaluation would certainly be appropriate at this point, and then the district should do that in an expedited manner. But despite Rooney's comments, that summer break does not stop those evaluation timelines. And then it looks like there's going to be disagreement. And what we're going to do here, be just in the interest of time, since we have 5 minutes left, I will just summarize what happens for the rest of the scene. But let's thank all of our volunteer thespians from the Bricker Graydon team and as well as from the SST. So we're going to have, so thanks everybody. We're not going to have an agreement here. It looks like there's going to be some sort of dispute as to whether or not Jill's misconduct was a manifestation of the disability. So who ultimately makes the call? We don't vote. We don't, raise hands or things like that. The person who has the decision-making responsibility here when there's a lack of agreement amongst the team members is the district rep. So it is Ms. Moneypenny who actually gets to make that call. And so what happens in the scene, if we had more time, we would go into the scene. It's just a couple more pages, but I want to be respectful of your guys' calendars. What happens is that the team talks about what may be necessary for Jill in order for her to make progress. The parent is concerned about her being at home and not being able to make progress and actually further exacerbate her mental health issues. And so the team talks about it because remember, it's an IEP team decision when there's a disciplinary change of placement. The IEP team determines that an alternative program that will keep Jill in school, but just out of Pleasantville is the most appropriate. And so ultimately the team proposes that, and that is a good solution at the end. But if there was further disagreement, the parent again could file an expedited due process case to challenge and any aspect of the discipline. So that the scenario is really intended to highlight the importance of compromise as well as effective communication skills. Now we have Miss Moneypenny who brings those skills to the team, but we also have some other folks like Ms. Rooney who are challenging in that regard. And so I know that this, we drafted this based on real IEP meetings that we have and that we've seen. And it's not always that it's the principal that says something unfortunate, but you have to know how to address that so that you can move forward productively. So with that, I'm going to look to see if we have any additional questions. Let's see. Oh, okay. So we have a reminder from the SST, and I will reiterate that reminder is please, please, please provide feedback about the training programs, about things that either the format, how we present the materials, all of those things. We definitely, we value the feedback. We think feedback is a gift, and we want to hear what's impactful for you. We will be having a couple more sessions of this ESELA series for the remainder of the year. So if you know folks who may need some additional professional development, check it out. I know that we are going to be doing dispute resolution, which is one that I will be doing. Claire might be also participating in that. And so we will be talking about some of the things that Ms. Moneypenny was doing during this meeting, like how to redirect and some of the things that she demonstrated. There is a question here: if the student attends a career center, who is responsible for the FBA and the behavior intervention plan? All of the obligations rest with the district of residence. The district of residence is responsible for legal compliance. And so if there is a hiccup somewhere, that is who the Ohio Department of Education will process the complaint against. Now, that doesn't mean that they won't bring in the career center, meaning the district of residence, but the district of residence always has the legal and financial responsibility. If a student has a behavior plan, the school has been following it and made adjustments, but the student still exhibits behavior like hitting the teacher, if the parent does not agree to an alternative setting, we would not be able to remove him, correct? Well, it depends. You cannot remove him if the behavior is a manifestation of the child's disability. But if the behavior is a manifestation of the child's disability and the student caused serious bodily injury, you would be able to remove. And then if it is not serious bodily injury, there can be a removal, but that could only happen with court intervention or through an order from a hearing officer. So it wouldn't be unilateral. Should the students have been at the meeting? That's a great question from Emily. We usually just don't have enough actors to fill those roles, but yes, of course, the student, whenever appropriate, would be somebody who's a required member of the team. And having the students, particularly high school students there, providing their perspective would be a good idea. All right, well, look at that. We are at 11:30. We made it. We sped through that. But I hope it was helpful to see it brought to life. So on behalf of the entire Brooker and Graydon team, really appreciate you guys tuning in and sharing this information with your districts. We'll see you next time.